Hello everyone, me and my groupmates are going to report about the involuntary registration and incidental therein. What is an attachment? An attachment or a preliminary attachment may be defined as the provisional remedy taken into the custody of the court as security for the satisfaction of any judgment that may be recovered. It is a remedy which is purely statutory in respect of which the law requires a strict construction of the provisions granting it. Rule 57 also speaks of the grant of the remedy at the commencement of the action or at any time thereafter. What the rule is saying is that after an action is properly commenced, the plaintiff may apply for and obtain a writ of preliminary attachment upon fulfillment of the pertinent requisites laid down by the law. Attachment is a mere provisional remedy to ensure the safety and preservation of the thing attached until the plaintiff can obtain a judgment and have such property applied to its satisfaction. Attachment is harsh, extraordinary, and summary remedy, and the rules governing its issuance must be construed strictly against the applicant. A writ of attachment can only be granted on concrete and specific grounds, and not on general averments quoting perfunctorily the words of the rules. A writ of attachment is substantially a writ of execution, except that it emanates at the beginning instead of at the termination of the suit. Issuance and enforcement of writ. The difference between issuance and enforcement is that issuance is an unlimited power to issue the writ upon the commencement of the action even before it acquires jurisdiction, while enforcement only be validly done after it shall have acquired such jurisdiction. In the case of Quartero versus Court of Appeals, the court emphasized the grant of the provisional remedy of attachment, which practically involves 3 stages. First, the court issues the order granting the application. Second, the writ of attachment issues pursuant to. Lastly, the writ is implemented. For the initial 2 stages, it is not necessary that jurisdiction over the person of the defendant should be For the initial 2 stages, it is not necessary that jurisdiction over the person of the defendant should be first obtained. Once the implementation commences, it is required that the court must have acquired jurisdiction over the person of the defendant, for without such jurisdiction, the court has no power and authority to act in any manner against the defendant. Lien when excessive remedy. The rule is that when real property of the judgment debtor is attached, the levy creates a lien which nothing can subsequently destroy except by the dissolution of the attachment. The lien obtained by attachment stands upon a high equitable ground as mortgage lien, which is a fixed and positive security which must necessarily continue until the debt is paid. The attached properties cannot be interfered with until sold to satisfy the judgment. There is no rule allowing substitution of attached property, although an attachment may be discharged wholly or in part. If an attachment is excessive, the remedy is to apply to the court for a reduction, partial discharge of the attachment. The lien acquired by the plaintiff creditor as of the date of the original levy would be lost. Duty of Register of Deeds to annotate. In Caviles v. Bautista, the court ruled that a party which delivers its notice of attachment to the Register of Deeds and pays the corresponding fees thereof has a right to presume that the official will perform his duty properly. Involuntary registration such as an attachment, levy on execution, lid pendants, and the like, entry thereof in the day book is a sufficient notice to all person of such adverse claim, and the notice should be annotated on the back of the corresponding original certificate of title, which is also the duty of the Register of Deeds. That would be all from my report. Thank you for listening.